Good morning. I'm Mark Kimball, and agenda item one this morning is the call to order. It's 10 a.m. on March 26th, 2026. I call this meeting of the Citizens Clean Elections Commission to order. With that, we will take attendance. Commissioners, please identify yourselves for the record.
Christina Werther.
Kalen Payton.
Sam Crump.
And I'm Mark Kimball, and I'm just checking to see if we have Commissioner Tidla. We don't have him at this time, but we've got 4 commissioners, so we have a quorum. Item 2, discussion and possible action on meeting minutes for February 19th, 2026 and March 19th, 2026. Commissioners, you have the minutes from the February 19th and March 19th meetings in your packet. Is there any discussion? Hearing none, is there a motion to approve the minutes for both of these meetings?
Mr. Chairman, I move to approve the meeting minutes for February 19th and March 19th, 2026.
Thank you, Commissioner Werther. Is there a second?
I'll second it.
I'll call the roll. Commissioner Werther,
Aye.
Commissioner Payton,
Aye.
Commissioner Crump,
Aye.
Chair votes aye. The minutes are approved. Item 3, the Executive Director's Report, including enforcement, regulatory, and legislative updates. Tom?
Yes, thank you, Mr. Chairman. Commissioners, a couple of things I wanted to highlight. First, our debate schedule is live on our website, and we'll be we've announced now our two debate series, our broadcast debate and our legislative and other debate series, one with Reister and the Arizona Media Association, and one with the Arizona Agenda in KCA. And we will look forward. Oh, bless you. Look forward to those starting soon. We're very excited about that. We're already here getting questions from candidates about scheduling and that kind of thing. And similarly, with respect to the folks' candidate profiles and getting ready for the voter education guide, we're getting lots of questions from candidates and lots of feedback, and I'm happy to report that our among all of our staff members, particularly Alec, we have very responsive to solving problems and getting folks set up, because there's nothing a candidate cares more about than making sure their picture is on the website when they want it on the website. And so we're doing that while getting ready for the local elections coming up in May on our website. So that's a lot of work. I also want to mention on April 18th, so I think before our next meeting, we'll have a town hall. So this will be our third town hall event. We had education in the fall, and then we had a healthcare related one in the winter, and then this will be water. And this will be in coordination with ABC 15 at their studios, I believe, and then it'll be broadcast or available to our media partners. So I wanted to mention all of that. On the legislative front, I think the one thing I wanted to highlight is we are working with legislators and staff members and other election officials on trying to get some adjustments made to this measure that would change the primary date from July or summertime to May. The reason why that matters for clean elections purposes is twofold. First, the way that the statute is set up, the schedule is built around a summertime primary, and so if you were to move the primary to May, you would essentially supersede the schedule for clean candidates qualifying. In other words, clean candidates, instead of having the period of time between the beginning of the qualifying period and the period when they can file their candidacy to collect $5 qualifying contributions, that would be reversed, and so they would not even be able to file their candidate paperwork, their clean candidate paperwork until after they had filed their petition. So it really short circuits the funding process. And then for our overall budget, it creates a situation where some spending, especially on potentially on voter education, will get pushed into the odd year. And the way our budget works for those of you when you think about we do this in December, we're set up to set these caps that run calendar year to calendar year. So if all of a sudden you have something that comes in at the end of the year, that would compress things again. So we're trying to see if we can get that, keep everything at the same level, but just extend the window for a 2-year window rather than a 1-year window, right? So there is an amendment out there that was discussed at committee. It did not get adopted at committee, but the sponsor of the bill seemed interested in working with us on that. So, and my goal at this point, and Mike's goal has been to work on language that doesn't actually change anything, right? So we're not trying to get any increase in funding for candidates or anything like that. We're just trying to essentially move the dates around so that the program it really is not superseded. And I keep using that word because, that's a Voter Protection Act term. So even if you wouldn't necessarily be amending the Clean Elections Act, you still can't supersede it. We will talk about, obviously, the Fontes, Clean Elections v. Fontes matter in a minute. On the Proposition 211 cases, after you all voted was it last week? Last week, we filed our cross appeal there. So I think those are the main things that I wanted to highlight. Yeah, I think those are the main things. Obviously, there is we have a rule that allows the executive director to close a complaint in the event that we get a response and we evaluate that. And those reports, that under that rule, I give notice to you all, and that's in the executive director report. I'm highlighting that because that's started up now for this election cycle. So we have one of those in the packet. So I think that's all I have, Mr. Chairman. Thank you.
Are there any comments or questions from members of the commission? Hearing none. Thank you, Tom. Item 4, discussion possible action, Arizona Citizens Clean Elections Commission versus Fontes. This item concerns the commission's ongoing litigation with the Secretary of State. First of all, the bottom line, we prevailed in court. And I want to personally thank our legal team of Bill Richards, Samantha Fox, and Isabella Van Deel. Very excellent job in the court proceeding last week. I wanted to first update commissioners that in public statements, the Secretary of State indicates they will not participate in an appeal, while the party's chairman told the Arizona Republic that the party would appeal. And secondly, I wanted to recognize this decision will avoid a tremendous amount of confusion and cost to the state and to voters. Bill, did you want to briefly explain what the court ruled? And we may discuss this more in executive session, but maybe you can give us an overview of where we are now.
Sure, thank you. Members of the commission, the court has granted a final judgment in favor of all 3 of the plaintiff parties. So it was the Democratic Party, Republican Party, and the Citizens Clean Election Commission. We had the first lawsuit filed. Each of the parties filed their own. We consolidated all of those into one, and the court has ruled in our favor across the board, determining that the decision of the Secretary of State to approve and recognize a name change for the No Labels Party to the Arizona Independent Party was legally unauthorized, exceeded the authority granted under law to the Secretary of State, and therefore that not only can the name change not be recognized at this time, but the guidance that the Secretary of State had provided to all of the county election officials to include things like change the party registrations for all no labels party voters to Arizona Independent Party. None of that can be implemented, and none of it needs to be honored by the county election officials. So that fully resolves that issue. The court has determined that the only way for a Secretary of State to recognize a new party name would be to follow the existing procedures under 16801, 16803, and go through the petitioning process that a new party that's never been recognized before would have to go through. Obviously, none of that was attempted here. So for the party involved, if they elected to continue with a name change, if you want to call it that, they would have to go back through that process according to the court's ruling. They have a opportunity to appeal, as I think Chairman indicated, that they've indicated, at least in the press, that the party intends to file an appeal. To do that, they would have to, I believe, move on a very expedited basis, given all of the other collateral concerns with the election process and where we are in it right now.
So just to summarize, they are back to being the no labels party as of now.
Yes, as recognized by the Secretary of State formerly, they are recognized as the no labels party.
Okay, thank you. We're going to discuss possible next steps in executive session, but are there any questions of Mr. Rich, of Bill in open session?
I have a question.
Yes, Commissioner Crump.
Yeah, I'm just curious for the candidates who went out and gathered signatures under the Arizona Independent Party, what will happen with those signatures now?
I can probably do it. Do you want me to?
Bill,
You want me to?
is that something you feel comfortable answering?
Well, it's something I don't have a final answer to, but I have a very, very brief answer to it, which is the initially, I believe what will happen is the Secretary of State will have to make a formal decision on how to recognize or whether to recognize those candidates' petitions as petitions for a no labels party candidate. And at that point in time, other interested parties could challenge that decision and take it right back to court if they elected to. And I can't predict the outcome of that. I think that's a pretty novel issue.
Thank you, Bill. Tom, did you want to add anything to this?
Yeah, just Mr. Chairman, Commissioner Trump, just that, as you know, all the candidate challenge period for nominating positions will be happening. I think does it start on Friday? Is that right? We're in it now. Okay. So so any candidate could be challenged, for any number of things, as you know. I think that so we don't know if that challenge is going to manifest itself yet. And I think that the thing that makes this a little novel, as Bill put it, is that someone will say, well, this name, you use this name on a petition rather than that name. The candidate, I think, inevitably will turn around and say, well, I was relying on this, good faith on what was going on, with this. And so I think that, I think that I'll just be candid with you all. I mean, I have sympathy for the candidates on that front. I mean, I do. I mean, I think that if you were in a position where you had, if you were to go on the eQual portal in the last few months and try to pick a candidate, your options were to pick the options that were presented to you were AIP, or if it was an independent candidate, no party. It is not at all clear to me that was a decision made by those candidates to select that, for example, on the online portal. And in our case, one of the I think 11 or so candidates actually tried to intervene on that basis, and the court didn't want to expand the proceedings. So I guess one thing, I was asked about this yesterday by a reporter, and I said, the first threshold thing is that any candidate who signs up to be a candidate faces the potential of having their petitions challenged. I mean, that's sort of life. But we haven't seen that yet, and I don't know how that gets resolved either. But I do think that in many cases in this type of situation, I think my experience, obviously Christina and or Commissioner Werther and Gina and Mike have their own. The courts attend. I mean, it's a substantial compliance is the standard. You complied with the thing that was there. I don't know. I think that there's a pretty decent argument on those behalf. Just to speculate a little bit about it.
Thank you, Tom. Any other questions in open session before we vote to go into executive session? Okay, I would entertain a motion to go into executive session to discuss this item.
Mr. Chairman, I move to go into executive sessions for item number 4.
Thank you, Commissioner Werther. Is there a second?
I'll second.
Thank you, Commissioner Payton. I will call the roll on the move to go into executive session. Commissioner Werther,
Aye.
Commissioner Payton,
Aye.
Commissioner Crump.
Aye.
Chair votes aye. We will be in executive session. Thank you.
Thank you. Sorry. Oh, no, you're good.
Okay, we are back in regular session. Is there a motion by any member of the commission?
Mr. Chairman, I'd like to move to authorize our outside counsel to make an application for attorney's fees and costs in the the Clean Elections Commission v. Fontes, and also to authorize outside counsel for the engagement and defense of the commission in any appeal.
Thank you, Commissioner Werther. Let me just ask a clarifying question of Mr. Richards. Do we need to make this in two motions, or are you okay with in one motion?
I think it might be best in two motions. It's involving two separate proceedings, so it's probably best in two.
Okay, thank you. Commissioner Werther, could you,
Yeah, I'll withdraw
Restate your-
my motion.
okay,
And then the first motion is to authorize outside counsel in the matter of the Clean Elections Commission v. Fontes to submit the application for attorney's fees and costs.
thank you, Commissioner Werther. Is there a second?
I'll second.
Okay, it's been moved and seconded that we authorize our attorneys to file a motion for reimbursement of attorney's fees. I'll call the roll. Commissioner Werther,
Aye.
Commissioner Payton,
Aye.
Commissioner Crump.
Aye.
Chair votes aye. The motion is approved 4-0. Did you have another motion, Commissioner Werther?
Mr. Chairman, I'd like to move to authorize our outside counsel, again for the Clean Elections Commission v. Fontes case, for their engagement and defense of the commission in any appeal.
Thank you, Commissioner Werther. Is there a second?
I'll second.
Thank you, Commissioner Payton. It's been moved and seconded that we appeal the remaining issues in this case. I'll call the roll. Commissioner Werther,
Aye.
Commissioner Payton,
Aye.
Commissioner Crump.
Aye.
Chair votes aye. The motion is approved 4-0. Thank you very much, Bill and Sam, for your time and your expertise.
Thank you.
Item 5, discussion and possible action on proposed amendments to AAC R2-20-702, use of clean funds. This is a discussion possible action on a proposed amendment to Rule R2-20-702 regarding the use of clean election funds. Tom, do you want to walk us through this proposed amendment?
Yes, Commissioners, you may recall we talked about this last year. This was a rule that we initially discussed this in two steps. First step was to restore into the text of the administrative code the specific items that are prohibited for clean candidates to use clean funds for. And that aspect of the rule, we were able to only to research so far that we don't know exactly why they were removed. We don't have anything on our end that says why, and the Secretary's office doesn't have anything on its end, but we are where we are. So that does that. We, as a practical matter, those items are essentially personal use items or not direct campaign expenses. So we have been functioning fine, providing those as examples and guidance. But restoring them into the rules also provides some clarity, right? So in other words, We haven't had a case yet where a particular item like that was an issue, and we haven't had anything fall through the cracks, right? So this is kind of a belt and suspenders thing at this point, but it's an important belt. With respect to the second point of discussion at the meeting when we discussed this, we had talked about how to deal with this sort of household expenses, household member issue, and we had some questions from Commissioner Crump along the lines of how we might compare that to what other states do and the impact on candidates. And our reflection on that, in the ensuing period of time is that probably the better way to deal with that, rather than try to find a codification that goes beyond what we've already said about family members, would be to treat that as an auditable issue. I think we have a line, or we have in the past, sometimes had a line in the audit about disclosing family members issues, so we can adjust that, and that would give us a better understanding of whether or not this is going to be a regular thing, and if it is a regular thing, whether it's we need to actually codify something. The statute itself, the Clean Elections Act itself, recognizes that family members can work for candidates. The rules have always recognized that. So it does get a little, and then it also gets into an issue of, how do you, I'll just be honest with you, when I was even drafting the proposal that we originally had that we did not advance for public comment, it got into an issue of how do you define that? What relationships do you want in? What relationships do you want out? So we think better to leave that alone. And as I say, I think with specifics here restored, we'll be in a stronger place than we were beforehand. The only other thing I'll note is, again, I don't know that this is necessary, but our statute provides for the commission, if you're unanimous, to allow for an immediate effective date. The Governor's Regulatory Review Council is not bound by that, but they do give it consideration. Because if you're not unanimous, that's not an option. So, so it's up to you if you want to indicate that. The notice, I believe, specified that was a possibility. And in any event, it would help us. We've in our interactions with GERC, to have that included in a motion. We don't always ask for that, I don't think, but just to have that in the record, if you all are unanimous, to be clear in the record that we would like to have this have an immediate effective date. And that's what I have. Thank you, Mr. Chairman.
Okay, Tom, I just want to clarify. So you are asking us to do what with this amendment? Approve it, put
Yes.
it out?
No, this is approved. Yes, I'm sorry.
Okay.
Yeah.
Okay, approve it and ask that that approval take effect immediately
Correct.
if we are unanimous.
Correct.
Okay, thank you. Any questions for Tom from members of the commission?
Mr. Chairman, I just have a clarifying question. So Tom, you were saying that if this is approved, so any issues would come up through the audit?
No, the rule itself would, which is what we've been telling people the entire time this wasn't on the books, right? The rule itself would go into effect upon GERC's approval if they gave it immediate approval. The specific issue that we had talked about in the drafting process and public comment process was whether we want to go farther and get underneath more the interaction where you have a household member who is working for a candidate, and how do you deal with this question of whether or not they are, for example, if I work for the candidate and the candidate's paying me, is that money going into the household budget, right? How do you delineate that? And that's a hard question. And we know that the statute and rules have always allowed family members to work for candidates. So we're not in a position where we could prohibit that. So how you measure whether or not money is going into the household budget, right? If I hire my boyfriend as a campaign consultant and we live together and I pay him, $6,000, let's say, and then our mortgage is, $2,500. I mean, how do you know, right? Because everything becomes sort of fungible. And so it's a real challenge from a regulatory perspective. We don't know how often that happens. We do think that having the specific articulation, right, in the rules restored around household gives us a little more oomph than just the direct campaign expenditure piece that we have in place, right? It shouldn't, as I say, change any outcomes of any enforcements, but it will reemphasize, hey, household, if you can't do it. So that I think flags for a candidate, I got to be aware of how this money's being spent, and maybe that means you can, whatever that means. And then we have our field audits that we do on the clean candidates, and we can work with our auditors to develop a better question that is going to be more tailored than any rule could be, to try to sort of dipstick whether or not there's a reason to believe somebody is using clean money for household expenses when it appears they're not.
Thank you. Okay.
Any other questions or comments from members of the commission? So, Tom, you were asking us to approve an amendment to Rule R2-20-702.
Correct.
Okay, thank you. Do we have a motion reflecting that?
Mr. Chairman, I'd like to move the approval of the proposed amendment to the Arizona Administrative Code R2-20-702, and also, if unanimous, that it take immediate effect.
Thank you, Commissioner Werther. Is there a second?
I'll second.
It's been moved and seconded that we approve the proposed amendment to Rule R2-20-702. I'll call the roll. Commissioner Werther,
Aye.
Commissioner Payton,
Aye.
Commissioner Crump.
Aye.
Chair votes aye. Motion is approved unanimously. Thank you, Tom.
Thank you.
Item 6, discussion possible action on MUR 25-03 Monica Timberlake. Item 6 is discussion possible action on whether probable cause exists to believe violations of the Clean Elections Act and rules occurred in MUR 25-03 involving Monica Timberlake, a 2024 legislative candidate. Commissioners, you have the executive director's brief. First, we will hear from the executive director, Tom, and then we will hear from Ms. Timberlake or her representative if they are present. Tom?
So, yes, thank you, commissioners. And just so you know, your independent advisor, Craig Morgan, is here if you have questions that are legal that are not mine to answer, because they're not. First thing I wanted to say is that I got an email from Ms. Timberlake this morning, or maybe late last night, that stated that she has an appointment on Thursdays that makes her unavailable for meetings. She also said in that she would be, or had, or was going to put in the mail a cashier's check for some remaining Clean Elections funds that she admits that she has. So I don't expect her to be here. The second thing I want to say is, these proceedings that we have around the repayment and failure to file have obviously taken a considerable amount of time. And we are getting closer to the end of these for this past year. And it took us a year to get this done, get this far. And I wanted to thank the commission for your patience as we, as staff members, have tried to work through these issues. One of the things that we tried to do at the outset of this matter was try to get something on record early to, with respect to repayment, in order to, demonstrate that we were moving and taking it seriously. And we have done that. Now, there was a period of time where we were optimistic we might get to a different place, and that's gone on. So we've provided, I don't know how many different types of notice, but That said, it does take a long time, and even in an ideal situation where we have, it would take a commission getting to a final penalty order, which would be not this step, but the next step takes at least 3 votes of the commission. So there's really no way to get these done in fewer than 3 months if everything lines up to do it in successive meetings, right? So the year is a pain. And I really appreciate your patience with that, but it's looking at it, it's not necessarily clear we could have cut it back I mean, we probably maybe could have shaved a month here and a month there, but part of this is if this goes this way, that's the way it goes. So I appreciate your patience with me and us working through this. So the third thing is obviously we believe that there is probable cause to believe that Ms. Timberlake violated the Clean Elections Act and rules in the manner set forth in the brief. Next we will, if you were to find so, we would return next month with a final order imposing penalty recommendation if we weren't able to resolve this short of that. The late filing matter is a serious matter, and the non-filing matter is a serious matter, and we take it seriously. The maintenance of books and records, I mean, these are all things that candidates are given notice of. They agree to through their decision to apply for participation under 16.947, and they they agree to that. We also the repayment issue, there is one repayment order, as you know, that we issued that was not appealed. There was additional penalties provided for failure to repay. In this case, we will look at that next month, but we do say that the failure to repay is itself a violation. And so that is, again, one of the things that we are saying there is probable cause to believe. And then finally, excuse me, the failure to provide records is itself a violation, right? So we think that in each of those matters, we think the facts are pretty unequivocal that there that there has those are violations. To the extent we've had communication with Ms. Timberlake, that communication has typically been around, and this is in the exhibits, her inability or to complete some of these processes, and I would simply say, I mean, to the extent that's an effort at a defense, I don't think that is a I don't think the standard here is excusable neglect, and I don't think that the neglect is excusable. So I would urge the commission to vote to find probable cause to believe here. And I'll answer any questions if you have them.
I just want to point out that this is not a poor reflection on Tom. It's on the respondent here, that it has been in August of 2024 when we provided Ms. Timberlake with $31,000 plus for her campaign. And since then, we've received no reports. We've been chasing her around the state. She's responded only to say she has personal issues and can't be there. We were supposed to take this up last month, and she said she couldn't be present. So we delayed it a month just in the interest of fairness. I mean, now it's been more than a year and a half that we've been trying to get some resolution to this for providing more than $31,000 in public money to this candidate and not knowing what happened to it. I think we've got to move ahead and find probable cause exists that she has violated the act. Any comments or questions from members of the commission? Hearing none, do I have a motion regarding probable cause in MUR 25-03?
Mr. Chairman, I'd like to move that the commission finds probable cause to believe that respondent Monica Timberlake violated the act and rules as outlined in the executive director's brief dated February 11, 2026.
Thank you, Commissioner Werther. Is there a second?
I'll second.
Thank you, Commissioner Payton. It's been moved and seconded that we find probable cause in MUR 25-03. I will call the roll. Commissioner Werther,
Aye.
Commissioner Payton,
Aye.
Commissioner Crump,
Aye.
Chair votes aye. The vote is 4-0. Just for the record, Ms. Timberlake, I don't believe is here. I don't see her on Zoom. I don't see any indication that a representative for her is here. If either Ms. Timberlake or her representative is here, please identify yourself, and we will be happy to hear from you. Hearing nothing, we will move on. Item 7, public comment. This is the time for consideration of comments and suggestions from the public. Action taken as a result of public comment will be limited to directing staff to study the matter, rescheduling the matter for further consideration, or responding to criticism. Please limit your comments to no more than 2 minutes. Does any member of the public wish to comment? Anyone on Zoom wish to comment? Hearing from no one, the public may also submit comments by email at ccec@azcleanelections.gov. Item 8, adjournment. At this time, I would entertain a motion to adjourn.
Mr. Chairman, I move to adjourn.
Is there a second?
I'll second.
It's been moved and seconded that we adjourn. I will call the roll. Commissioner Werther,
Aye.
Commissioner Payton,
Aye.
Commissioner Crump,
Aye.